I think Davion, for one thing, hasn't been involved in the system much. He has been scared about this whole thing and trying to do everything as he thinks is right in regard to this. You know, he has the one disorderly conduct reduction on Miamisburg. I saw that there was a warrant according to the PSI. I talked to him about that and said that that was for fines that were paid last month or earlier this month in May. You know, so that shouldn't be an issue. But yes, Your Honor, he knows he needs to stop using. We talked about how just like alcohol, something can be legal, but it's not always the right thing to do, and especially when you're on probation and being told not to do it. So I think he understands that. Your Honor, the only other issue I would have is that, I don't think there's been a no contact order through this entire case for the most part. They do have a child together at this point, and he sees that child every day. So we would ask the court not to impose a no contact order upon Mr. Terrell.
Okay, thank you. Mr. Terrell, is there anything you'd like to say, sir?
Yes, Your Honor, I would like to just be honest and apologize for lying about my misuse. I did use recently within the last month of marijuana, and I just wanted to be honest about that in the state, me denying it.
I'll ask you the same question I asked Mr. Kidd.
Yes, sir.
What can I do to make sure that you decide to stop? Because I don't think it helps you get a job. I don't think it helps you be a better dad, which I believe you want to do.
Yes, I do.
I don't think it helps you to be a better co-parent. I can't think of anything that helps you do, really, other than feel good, maybe for a while. So tell me what you think I can do to make sure you stop.
There's not really a lot of options, Your Honor.
I do have one option. I can put you back in jail.
Right.
That's one option.
Right, and I understand that, which is why I can only say treatment. That's the only thing I can really say, because there's not a lot of options. You honestly just gave me a lot of chances, and I still have it in my system and messing that up for me.
Okay, go ahead. We'll move on from that subject.
I do want to say that I do understand the circumstances of my situation and what's going on and what I've even put myself in within dealing with all of this, and that I do understand that even just allowing this to happen, allowing someone to even get under my skin within words, or no matter how disrespectful, I should never retaliate out of emotion to even I never wanted to cause any harm towards anybody or anything. And I just wanted to let you know that I at least grasp the understanding of my circumstances and my situation.
Okay.
And this is something that'll never happen again.
There's a warrant for his arrest, is that correct?
That was the Miamisburg situation that he says that has been lifted.
Yeah, I just got taken care of that. I paid the fine for that. It was $50.
Okay, so that was the same case that you got 6 days.
Yeah, so around Thanksgiving weekend.
Okay.
Just so the court knows, Your Honor, I did not independently verify that, but I did ask him about that warrant, and he said that it was for fines that he did pay.
It was for fines.
Your Honor, we can run his record again. It was probably that we ran this to complete the pre-sentence investigation, and then we can rerun it again to ensure that there's not an active warrant.
Okay. Officer Niemeyer, what's the probation recommendation? I'm having some keyboard issues here.
Your Honor, we are recommending that he be placed on community control at this time. Obviously, there is some concern in regards to his ongoing use of marijuana, which he has now been fully advised that he needs to stop. We are also recommending that he engage in substance use disorder and mental health treatment as recommended by his Talbot House assessment, and then also that he completes the Batter's intervention program, and that he obtains and maintains verifiable full-time employment and no contact with the victim.
Okay, Officer Henry sent me an email on that this morning, and I think he said if I'm not mistaken, email said unless she wanted it dropped. Am I mistaken about that?
It does say that he would recommend a strict no contact order enforceable through probation if requested by the victim in the case.
Okay, so.
She's not here to recommend, or to ask for that, Judge.
And the victim is pregnant, it's mandatory prison. So. Count 1 is 2 to 3 years. The sentence on count 4 is 2 years to run concurrent.
Your Honor, previously you gave, that's a fifth degree felony. You
Fifth
previously
degree,
gave a
12 months.
Yeah, previously you gave a 6-month concurrent
Okay,
sentence.
6 months,
Okay.
but it runs concurrent, which means it runs at the same time. So whether it would be 12 months or 6 months, it runs at the same time as count 1. With regard to the 2 to 3 year indefinite sentence, 2 is considered the minimum. It's rebuttably presumed that you will be released from service of the sentence on the expiration of the minimum prison term imposed in this case, or any presumptive earned early release date. The Department of Corrections may rebut the presumption if, at a hearing, the department makes specific determinations regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. If the department at the hearing makes these specific determinations and rebuts the presumption, the department may maintain your incarceration after the expiration of that minimum term or after that presumptive earned early release date for a length of time the department determines to be reasonable, subject to the limitation that requires release at the end of the maximum term. The department may make the determinations and maintain your incarceration under the provisions I just described more than one time. You're released no later than the end of the 3 years. If you've not been released prior to the expiration of the 3 years, then you must be released on the expiration of that term. With regard to your release, you're subject to post-release control, which is supervision by the Adult Parole Authority. If you violate the terms of post-release control after your release, the Adult Parole Authority can send you back to prison for 9 months per violation, up to a total of 12 months. If you are convicted of a new felony during that period of supervision, the court that has the new felony case can revoke the post-release control, impose whatever time remains on supervision,